Okay, good morning, and thank you very much for joining us. I should be saying Eid Mubarak. We thank God, those of us that have completed 30 days of fast, and as people say, the people who were breaking their fast all sorts of unprescribed times are now in shame. We've ended the fast. Happy Mubarak to you all. Okay then, but there's still some business to do. Maybe I should just quickly introduce my guests to you, and you begin to get something of an idea of where we're going this morning. First of all, Mr. GT Ogunye, lawyer and public affairs analyst. Thank you very, very much for coming.
Yeah, it's my pleasure.
And Eid Mubarak.
Thanks.
I'm really going to town with it.
Yes.
And say Eid Mubarak back to me now.
Eid Mubarak. I'm Nigerian, so I'm watching outside. Yeah.
And then Mr. Onyebuchi Ememanka, who is also a lawyer and a public affairs analyst. Eid Mubarak.
Eid Mubarak.
There you go. Thank you very much. But we're here
It's
for
a
very,
pleasure.
very serious business because we're looking at Abia. And there's a sense in which Abia is still in something of a turmoil. We thought we knew where we were going back almost a week ago, but it doesn't look quite as clear anymore. We started off, when we started looking at it on this program, we started off with, okay, Justice Okonabang has made an order, so why is the governor still in place? Why hasn't the person who, was the beneficiary of his ruling been able to, take possession, so to speak, of that victory? But it's been explained to us since that it doesn't exactly work like that. There is a right of appeal. Now let's talk about that a bit, because there are people who are saying that INEC is part of this crisis in the sense that they opine that the INEC exhibited somewhat unseemly haste. Is that something you'd agree with?
Absolutely. But before then, it is important to lay some very critical foundations in this matter. The judgment of Justice Abang was premised on tax. Nigerians should know.
Okay, by the way, I forgot to mention it. It's important that in the interest of full disclosure,
Yes.
you are indeed on the side of the sitting governor.
Absolutely.
In this whole matter.
Absolutely.
So that is where, and
Yes.
we've had lawyers who have also canvassed the position of the side of Mr. Obi.
Yes, absolutely. Now, Nigerians should know that payment of tax is not a condition for anyone to contest for the office of governor in Nigeria.
And you're going to the real heart of the matter then.
Oh, yes.
Because it's all about the allegation of forgery against the governor, that
Absolutely.
he actually forged and that his certificate was no good.
Absolutely.
Okay.
Now, this is a constitutional democracy. The 1999 Constitution of the Federal Republic of Nigeria and the Electoral Act 2010 as amended have absolutely no single provision that payment of tax is a condition for elections. That's number one.
That's the Constitution.
Yes, and the Electoral Act.
And the Electoral Act.
Yes.
But the party guidelines of PDP state very clearly this particular point.
Now, if there is a conflict between party guidelines and the Electoral Act and indeed the Constitution, you know what happens. Section 1 of the 1999 Constitution is very clear on that. That where a conflict exists between this Constitution and any other law or any other rule, that other law becomes ineffective, becomes void to the extent of inconsistency. So by the state of our laws, there is no requirement for payment of tax. I believe the tax papers were added to the documents in the abundance of caution, what we lawyers call ex abundante cautela. It is not a condition. This point must be clearly noted. It is therefore intriguing that something that is not a condition to run election in the first place is now being used as a ground to ask a sitting governor to vacate from office.
Because, as I said, we've had a few days at this, and we've learned from lawyers coming in that there are matters that are pre-election and there are matters that are post-election.
Absolutely.
And that the attempt to unseat the governor this time, Mr. Ogunye, is relating to pre-election matters, in the sense that the plaintiff then is seeking to prove that the ultimate winner, the eventual winner, actually shouldn't have been in the race at all because he was not qualified.
Exactly.
Is that a summary?
Correct. That's what a pre-election matter is all about. But let me say this. You know, in the public interest, this matter...
And by the way, for public disclosure, since I did talk about him, you, to the best of my knowledge, are in no way in particular connected with this case.
I'm not connected to the case.
You are concerned here with
not connected to the case.
The points of law.
Yeah, exactly. Now, let me say that in the public interest, we have to continue to discuss this matter, but we must exercise caution because the matter is still a live matter before a court. And so we cannot discuss the merit or demerit of the case per se as if we are predetermining or prejudging the matter, or we are predicting how certainly the case will go. It is correct, as my learned friend in his preliminary remark has stated, that payment of tax is not one of the conditions for qualification for an election into the office of the governor of a state prescribed by the Constitution. And here I reference Section 182.
Absolutely.
It's also not one of the conditions stated in the Electoral Act. However, in the Constitution, reference is made to a forged certificate without elaborating what a forged certificate is. And in my view, if you forge a tax clearance as part of your documentation, you will be caught by those provisions and all. And the allegation here was not about non-payment of tax, but it was about falsification of tax papers and documentation. And in my view, if that allegations were proven, that might be a ground, to disqualify a governor. But that said, where we are is that a court of competent jurisdiction adjudicating a pre-election matter are taking a decision. And in that decision, the court directed INEC to issue a certificate of return forthwith to Dr. Oga. And INEC, post haste, indecently, if you ask me, did so. More so when, if you look at the core functions of INEC has not been able to deliver on those staggering elections and all that. INEC could argue that yes, there were factors beyond its control that warranted the staggering of this election beyond the time prescribed by the court decisions in those various cases and all that, including the Rivers State rerun that INEC has now told us is now ready to conduct. Now, INEC indecently, in my view, issued that certificate of return. But INEC will argue also that having been directed by the court to immediately issue a certificate of return, and having regard to the provision of Section 287 that enjoins all authorities and persons to enforce and comply with court's orders, that what is done, even if it was not doing so in the past, in this new era, was to just comply with what the court has directed it should do, and therefore it could not be blamed for what is done. However, there is a distinction between being issued a certificate of return and being sworn into office as a governor. The governor was sworn into office and is still the governor. Dr. Oga has a certificate of return via the court's judgment and the compliance with same by INEC. Now, what do we do and where do we go from here? The governor, Dr. Ikpeazu, has filed a notice of appeal, and he's also filed an application for stay of execution of that judgment. That application came up before the court, some days ago and was adjourned to the 7th, which unfortunately has now fallen into a public holiday. And so we'll know what the court is going to say thereafter, say on the 8th, Friday, or even Monday. But the law that I know, and I don't lay any claim to knowing a lot of law, the little law that I know says that, and that has been the point of division between lawyers amongst the commentariat, if you will. A school of thought says that, oh, comply with that order immediately because it's a declaratory judgment, because the court directed that you comply with it, because the court says that, so comply with it. And another school of thought says no, because there's a notice of appeal and there's a stay of an application for stay of execution. And until that application is decided one way or the other, you can't comply with it. I think that the latter school of thought is correct.
Okay,
that's what the law
that's where
says.
you would lead.
That's where I lean. That's what the law says.
Okay.
You see, when matters break like this,
yes,
people with biases and partisan positions come and start interpreting the law to suit their own whims and caprices. That's not where I live. That's what the law says.
That's okay.
And I challenge anyone to the contrary, that if you have a notice of appeal and you have an application for stay of execution of the judgment, whether you are contending that that judgment is declaratory or not, although my position is that even if you bring a declaratory relief to the court and outside consequential relief, you then have the judgment giving specific directive, issue a certificate, swear him in and all that. That makes it an executory judgment more than a declaratory judgment, which can be stayed, whether that's your argument or not. Once that application for stay is filed, until the court decides one way or the other, matters have to remain in status quo. That's the little law that I know.
Fine, thank you. Coming back to Onyebuchi, the other intriguing point that has come up is the matter of, one, initially, when it was still early, whether notice had been given of any appeal. And those on Dr. Oga's side had said there was no such, action. But it has now unfolded that the lawyers from the governor's side claim that we did indeed serve notice of appeal, nevertheless, including on INEC, and nevertheless, INEC went ahead and issued that certificate of return. And the argument of INEC is very much as Mr. Ogunye has explained here, that look, it's bound by the law to react speedily, even though Mr. Ogunye has put his comment on top of that. So there's an issue here. Why were they moving forward if there was indeed a notice of appeal? Additionally, INEC has also said that in relation to the whole matter of taxation, INEC has said that, look, we issued it immediately, but just did not deliver it on that same day.
That is the intriguing point. That is the intriguing point.
We just did not deliver it until the day that people are talking about,
happened,
which is a Sunday, I think,
what
or
took
Saturday.
place in Abia State last week was nothing but a civilian coup d'etat. First of all, this judgment was delivered on the 27th of June. The enrollment order of Justice Abang was made available on the 1st of July. The certificate issued to Dr. Oga was dated 28th June, less than 24 hours after that judgment was delivered.
Is that surprising to lawyers?
It's immaterial. Once a judgment
the speed with which I'm talking about the speed.
You know why I'm saying that, my learned friend?
Let me come down. Let me land. Can I land?
Let me just say this.
I allowed you.
No, we are not adversaries.
I know, but let me land. You see, when lawyers to Dr. Ikpeazu, Governor Ikpeazu, served INEC with documents, notice of appeal, and stay of execution.
When was that?
They were served 2 days after.
Okay.
A day before the certificate of return was purportedly issued to Dr.
And by which time INEC said it had already issued that thing in compliance with Justice Abang's ruling.
The question here is, what were they served? What was INEC served? On what basis did INEC issue that? Were they served any enrollment order?
Okay.
That's the issue here.
That is, let me understand this, not being a lawyer. This thing you're calling an enrollment order is the communication of the judgment formally and officially to INEC.
Absolutely.
Okay. Because INEC would have heard, but
absolutely
in the newspaper, on the radio is not it.
They cannot act based on what they heard on the mass media.
Okay. So
that is the where we are worried.
So the question you're
Why
asking
the haste?
the rhetorical question you seem to be asking is, so when was INEC served this, what did you call the order? Enrollment.
The enrollment order. Now, INEC has started lying. First, after being duly served with Governor Ikpeazu's notice of appeal and application for stay of execution. Initially, they said, we were not served. When the Abia State Attorney General provided evidence that service was indeed conducted, they now say, oh, we were served with just a notice of appeal and not stay of execution. When a man starts lying, he keeps lying.
Okay. So
if you lie on an issue, you will continue to lie. So the issue is that INEC was part of this grand conspiracy. It's a grand conspiracy to flung away a sitting governor, a situation that is unprecedented in Nigeria's electoral history. It has never happened. Why do we have two other courts above? Now, I keep asking this question, Mr. President, and let me make this clear here. If the intention of the lawmakers was that a court of first instance can take away a governor from office, even when his appeal is pending. Have you considered what would have happened in Abia State by now if Dr. Oga actually was sworn in last Thursday? Of course, he would change the cabinet, he would dissolve so many boards, he would take economic decisions, and 2 months later, the Court of Appeal says, no, the High Court was wrong. Governor Ikpeazu, please come back. Have Nigerians thought about the turmoil, the confusion that would have been occasioned by that? This is why it is always better in election, in case issues that concern public officers, like the office of a governor, to wait until the final court takes a decision.
I get your reasoning. But let me bring to Mr. Ogunye the point that Justice Ikpeazu, when he revisited the matter,
Justice Abang.
I beg your pardon, his governor Ikpeazu and Justice Okon Abang, when he revisited the matter,
Okon Efereti Abang.
Yes, when he revisited the matter, and there was this whole issue of, I think, the stay of execution. He had said that he didn't feel that he needed to be bound by, a court of, similar, jurisdiction on the one hand. Two, he actually cautioned. He said that people should take caution who have not actually studied the judgment, and it's not as if it's a one-page thing the way a lot of us are talking about it, and that it's a very, very reasoned process, and that he's standing by what he first said, and so much so that my order, one of the papers this morning encapsulated in, my order sacking Ikpeazu stays until it is shifted by, he used the proper language lawyers use, until that position is shifted by a higher court. A bit confusing here. Why would another high court try to, shunt what a high court had done? Could you explain that to us? Is this, it looks like this is becoming something of a legal, well, it is legal warfare, but I don't know.
It need not be so. If Dr. Ikpeazu didn't become jittery unnecessarily. I have more faith in the legal process, in the judicial process. And even if it appears that mischief is afoot, you just have to deal with that process and ensure that you get justice through it. Not by also embarking on mischief yourself.
Okay. I think the other party called it self-help.
Procuring an order of injunction from a court of coordinate or concurrent jurisdiction is an abuse of court process. The Federal High Court granted that order. We've been told that a notice of appeal was filed, and that has been acknowledged. INEC has not accepted that notice of appeal was coupled with an application for stay of execution. However, eventually, that application for stay of execution was filed, regardless of whether INEC acknowledged that it was served on it when Dr. Ikpeazu claimed that it was served on it or not. And eventually, that application for stay of execution has now surfaced in court, and it's now been heard, and it will be determined. Now, I have argued the procedure that once a judgment is delivered and there's a notice of appeal, by the way, Section 16 of the Court of Appeal Act, Section 17 of the Court of Appeal Act says that a notice of appeal without more does not operate as a stay of execution of judgment. So we know all that, and that's considered. But once a notice of appeal is filed and an application for stay of execution is also filed, until that application for stay of execution is determined one way or the other, first by the court that delivered that judgment, which is the court of first instance, and later on by the Court of Appeal, if that court refuses that application for stay.
Which has happened.
Which is not refused it because it's just reiterating his order.
Oh, okay. That's different from...
That's different from formally refusing the application. Okay. That application is yet to be determined. Okay. It's just saying until something happens, that order stays. That is stating the obvious. Until an order is set aside by the court that gave it, or overruled or set aside by a higher appellate court, that order stays, and it's just merely saying the obvious. So that procedure for me is sacrosanct, and there can be no impatience or urgency or haste that ought to trump that procedure. Now, the other thing is that, which my learned friend talked about, he talked about the intendment of the lawgiver. And although he didn't mention it, it's a veiled reference to Section 143 of the Electoral Act. People have argued that Section 143 of the Electoral Act is not applicable to the present case, which is a pre-election matter, because Section 143 essentially applies to an election petition. And what Section 143 provides, by the way, is that after an election petition is determined one way or the other, that once there is a notice of appeal, that governor whose election has been nullified will continue to stay in that office until the appeal is determined one way or the other. Now, that's the intendment of the lawgiver regarding election petition matter. And you can look at this and say that, it is to the same effect. An election petition seeks to nullify the election of a governor. This one seeks to disqualify a governor that may be sitting so that he will be sacked from office. That is to the same effect. However, whether it is to the same effect or not, the other procedure that says that once you file a notice of appeal and an application for stay of execution of judgment, still applies. And so until that application is decided one way or the other, you cannot even proceed. Now, finally, a lot has been said about INEC's undue haste in complying with this, and my other friend also spoke about it. He saw mischief, he saw a grand design to remove the governor from office. Indeed, he went as far as calling it a coup d'etat.
Yes.
I will be more restrained in looking at it that way. Why? There is no provision in our law that says that a public authority can only comply with an order of court only when it's received the enrolled order of the judgment.
Okay, okay.
Mind you, INEC was part of this case. INEC had his lawyer in court.
Okay.
INEC's lawyer had the judgment being pronounced. From the moment the judgment is pronounced, that's why a judgment is read in open court and pronounced, it becomes a judgment.
It takes immediate effect.
So an enrolled order is a communication of that judgment. So if INEC decided to comply with the judgment before an enrollment of order, got to it, you can't fault INEC on that score.
Okay. Now,
the point I made. The point I made.
You've made the point.
No,
You've made clear.
I want to react to some issues that he has raised.
React.
Okay, maybe just could you take 5 seconds to round off, please?
Yes, the point I have made is that you cannot. INEC has a latitude to say, we are merely complying,
Which they have done
which
already.
they've done.
Yeah.
So
Okay.
if you want to hold INEC for what is done and accuse of precipitating what is going on in Abia State, maybe you need firmer grounds to so accuse.
Okay.
INEC.
You wanted to
Yes, let
comment on all
me
of that.
react. He raised a lot of interesting issues. The first is that Governor Ikpeazu was panicking. He had,
Well, he said
he-
if he had not panicked,
yes,
you know,
there was every need for panic. You see, when INEC went ahead to issue this purported certificate of return, the information was all over the media that Dr. Uche Oga, he actually said it on several social media platforms. Oh, I am heading to Umuahia for my swearing in. No governor will allow that to happen.
And is that why the chief judge, according to reports, was not available to complete the
please,
process?
I am coming to that. Now, he also raised the issue of the High Court of Abia State's judgment. I want to address that very clearly. Now, the issues before the High Court of Abia State and the Federal High Court are two different issues. Maybe unrelated, but two different issues. Different parties.
May be related,
Yes.
but are different.
Different. The parties are different. Now, the Chief Judge of Abia State was a party in the matter before the Abia State High Court. Now, let me say this, that a court of law has a duty whenever its jurisdiction is properly invoked to take action and stop any constitutional mischief. Now, the court of the Abia State High Court received an application asking it for two reliefs. First, stop INEC from issuing this certificate of return. Secondly, and most importantly, stop the chief judge from administering the oath of allegiance on Mr. X.
In other words, from swearing him
From
into
swearing
office.
him into office. That was never an issue before Justice Abang. Indeed, the order of Justice Abang never included any order for swearing in. The Constitution is very clear on how a person can become governor. After all the other electoral processes, you must subscribe to the oath of allegiance before you can become governor. Certificate of return doesn't make you governor.
But it does suggest
It's a step. It's a step.
Thank you. In that quaint word that you lawyers use, the intendment
Until that step is completed.
was for the man to become governor.
Yeah.
Is why you said,
That
and
is-
you can't do that without a certificate of returns.
Now, there is a dispute. What the governor simply said is, look, don't swear him in when my appeal is pending. And the application before the High Court of Abia State had processes.
Okay.
The judge saw processes of appeal, saw notice of appeal. If you were a judge, what will you do in such a circumstance? A citizen of this country has filed an appeal, filed a motion for stay of execution, and somebody is rushing to be sworn in. So it is important to differentiate between the case that the order of the High Court of Abia State and that of the Federal High Court. Two different cases. Swearing in, sorry please, let me finish. Swearing in was not a part of the orders of Justice Abang.
But it was implied.
No, you can't imply a court
can't
order.
imply.
You cannot imply
You
a court
can't
order.
imply.
It must be definite.
Since a certificate of returns has no purpose whatsoever apart from that of making you the
Towards the final destination.
Okay,
Now,
and-
until you reach, it's just like
And that was
it's
tactically
just like qualifying.
truncated.
It's just like qualifying
yeah.
for the semi-final of the World Cup, and you say, "Give me the cup," without playing the final.
I'm not too sure the analogy is perfect. But,
It is.
But I understand what
It
you're
is
saying.
a step towards the final destination.
Okay, I'm
And-
going to come back. I'm going to come back
No,
to you.
please, let me make this final point.
No, you can't.
About the
I
chief
beg your
judge.
pardon.
No, it's
you
very
can't.
important.
I've got to go to break, but I'm coming back to you.
Okay,
You
all
know,
right.
I've got to go back to. I've got to break, but I'm coming back to you. This
Okay.
is getting really exciting, isn't it? We'll stay with us. We'll be right back. Okay, welcome back. Keeping our gunpowder dry. You landed there, but you might have not have landed where you want to. But I want to bring in another matter, which is the substantive, the whole backbone of this whole case, which is the allegation of forgery. We spoke at the beginning about how you need to be tax compliant. You need to have paid your tax if you're going to go for any office.
Absolutely.
I mean, anything, even business.
Yes. It's a civic duty.
As a civic duty. And the charge is that the document showing that Dr. Okpeazu was in good order was actually forged. And that was the basis upon which this whole action commenced, that he was not a fit and proper person to actually, stand way back in the primaries. Now the Inland Revenue Service in Abia has come along, and as far as I'm concerned, being unlearned, has complicated matters by saying that, did anybody remember to ask us any question? Because if we had been invited, if we'd been summoned, if we'd been subpoenaed, we would have told you straightforwardly that that is not a forged document, that the man paid tax. What's that all about?
Now, before that, let me say, I was almost landing somewhere before we went on break.
If you landed enough.
No, I didn't.
You see, this is not the court of law.
I
You
know,
don't have all the time.
I know, but let me make this point quickly.
Okay.
There have been insinuations that the Chief Judge of Abia State absconded.
Okay.
That is the language
Well,
I heard.
She herself has said that she was in court.
Absolutely. Nigerians must understand that.
But you did say there was a tactical need to prevent the chief judge from swearing in anybody.
No. Tactical need meant going to court to get an order.
Okay.
The Chief Judge of Abia State was at her duty post throughout that day. A judge that delivered 4 rulings in open court,
as we have read in the paper,
could not have been said to have absconded.
But address the issue of the forgery allegation.
Beautiful. Let me now say that. This is the first time in my whole life that I am hearing that a public servant evaded tax, or that a public servant forged tax papers.
And that's because public officials get their taxes deducted at source.
Once you see, a public servant has no discretion over tax. You must pay. Once your salary is paid, before your salary is paid, your tax is deducted. And no public servant is issued receipts whenever your taxes are deducted. It is when you need it.
Yes. Okay.
You apply. Your employers have a legal obligation to deduct your tax and pay over to the Inland Revenue Service. That was what happened to Dr. Okpeazu.
Okay.
Now,
so
let me come down. No, I've not finished, please. No, I've not finished. I've not addressed the issue of falsification.
Okay.
I've not addressed the issue of falsification.
Please.
The fact that Governor Okpeazu paid tax is not in dispute, because he was not in any position to evade tax. He didn't have the discretion to. Now, the next question is, if you apply for tax papers, who do you apply to? You apply to the Board of Internal Revenue. Dr. Okpeazu duly applied to the Board of Internal Revenue. The Board of Internal Revenue issued those documents. The Board of Internal Revenue has never complained to anybody that they didn't receive the taxes of Governor Okpeazu. The Board of Internal Revenue of Abia State has never said that these documents did not emanate from us. Indeed, they have gone a step further to issue a public statement saying the documents in question were issued by us. What else do people want to hear? Now that brings to the issue of how the case before Justice Abang was commenced. Falsification, forgery are criminal offenses. I am asking my learned colleagues, can you make a finding on a criminal issue by affidavit evidence? Can you use originating summons to commence an action that has criminal coloration?
Evidently, the answer is no. The way you're asking it, it seems...
Absolutely.
To lawyers, it's a rhetorical question. Is that right, Mr.
You can make a criminal allegation in a civil proceeding. The only thing is that the burden of proof will be beyond reasonable doubt.
Absolutely.
You can make a criminal allegation.
So theoretically, it's possible, but practically, it's an uphill task.
No, practically, how are you going to commence a criminal proceeding against a city governor who is covered by immunity?
By immunity.
No. That's why I'm saying that my duty here this morning is to look at the procedure. Because, I don't want to be caught by the desperation of politicians who are always eager to occupy political offices but usually reluctant to deliver on their election promises. I don't want to be caught by. All I'm arguing is that there's a procedure. And if eventually the court vindicates Dr. Oga on the authority of Obi and INEC, his mandate, his tenure will start from the day he's sworn into office. So he's not going to lose anything. There's really no need for any desperation.
Absolutely.
Okay, so
Really?
it was in that sense that
Really?
you said something what Dr. Kwezu did could be interpreted as being
And that's why I said,
panicky.
and that's why, you know, my friend has tried to justify going to court in Abia State. Look, if this matter were to be revisited by the NJC, somebody may have to be sanctioned. And some lawyers who precipitated and instigated the invocation of jurisdiction of that court may have to also be sanctioned by their professional body, because a court of competent jurisdiction is already dealing with the matter. Lawyers can change the name of parties. You can go forum shopping. You can go to another court, but essentially you still be asking the same thing, i.e. truncate the execution of the order of that court. We saw all these things happen during the June 12 election crisis days, when some courts were granting orders and so on and so forth. And in part, that was why Abacha then, you know, inspired the Decree 107 that expanded the jurisdiction of the Federal High Court, which we now have in Section 251, to domicile all cases against the federal government in the Federal High Court.
Not all, my learned friend, not all. There are instances where
you know what?
A state high court will assume jurisdiction in a matter involving a federal agency. For instance.
Okay, no, hold it please, because all this while, Shedrack in Cotonou has come on the line and wants to join this conversation. Good morning, Shedrack.
Yeah, good morning. How are you?
Good morning, sir. Thank you for calling in.
Yeah, I'm joining this program. This program is like a breakfast for me every morning if I need to do something else.
We're glad.
To the point.
Yes.
I'm a good citizen of Nigeria. At the same time, an individual of other states. What is happening today is giving me great joy. Since the creation of our other state, no man from Ngwaland has tested the power of governorship. This is our first time of testing it. And the challenges behind it is what I don't know exactly what to describe it as. Our governor is a civil servant in this case. I know that when once you are not an independent person, you are working for somebody, before you get your salary must have been your taxes must have been deducted. So in this case, I would have appealed to those people trying to incite problems in other states to go and look for something else to do. So I also will participate in the good work that they have been doing. So far, other states might be going to attack my own town. You will see the kind of dividends, the dividend work of democracy. So we don't want anybody to interfere. This governor perform his constitutional right to the end of his tenure. Then we can judge him from his works.
Okay.
For them to be putting this right at us this time, we can't welcome it from any person. So I am telling you that our governor is a governor. He remains here and not
okay, Shedrack, thank you very, very much for calling in. I apologize, for the bad quality of that Airtel line. We've been having this problem, unfortunately. So it's the next one we might be lucky, it might be good, but just to apologize that we have this issue with us. This crackling, this distracting from what is being heard. But we did manage to salvage some, and he seemed to be saying something along the lines of those who are looking.
Now, this is the first time somebody from Ngwaland will become a governor. That's also another dimension to the whole thing.
That's the
So
I'm an Mgwaman. Can I react to that?
For people like that, whether this cause is just or not, this is our turn. Don't frustrate it.
These are part of the complications. As an Ngwaman, you wanted to say something in relation to Shedrack from Cotonou.
Absolutely. You see, Abia State has 3 senatorial zones. Now, there's what we call the Abia Charter of Equity. which was put in place by the founding fathers of the state to give every unit of the state a sense of belonging. Abia North produced former Governor Joseph Okalo for 8 years. Abia Central produced former Governor T.A. Oji for 8 years. It is the PDP as a party made it clear that we are zoning our governorship ticket to Abia South. In the PDP primaries...
Where does Dr. Oga come from?
Dr. Oga comes from Abia North.
Okay.
In the PDP primaries, Dr. Oga was the only candidate from Abia North that contested. The rest were from Abia South. So, you see, this matter...
It's a factor. It's an important factor.
Very serious. You see, this matter is very emotional for our people.
It's not South dichotomy in Abia State.
So,
It is-
but that
this
doesn't
matter
have, I understand the importance
it has
of
no
it,
constitutional-
but it doesn't have anything to do with the law.
I agree. I
Again-
agree.
Again, let me bring in Michael, who also wants to
agree.
join this conversation. Calling in from, is that Sulere, Michael? Good morning.
Good morning.
Ogba, from Ogba. Here goes this Airtel line again, but let's see what we can do. Go on, please, Michael.
Good morning, Okunyori.
Good morning, sir.
Good morning, Okunyori.
Good morning.
I want to talk as a layman here.
Sure.
Hello, can you hear me?
Yes, we can, just about.
I want to talk as a layman here.
Sure.
It's time for us to put a stop. It's time for us to put a stop into all this. For example, let's look at it. I'm a politician. If I want to say, okay, I want to read to get into this, which I will read to get into this, the next time they will take me to High Court. Taking me to High Court, I'll use 6 months, they'll take me to Supreme Court, Appeal Court to Supreme Court. We are just disturbing ourselves. One way let us use 3 courts, High Court and whatever, to give a judgment as a seat. Because the man is doing this, they were like, Master, my son will be there, my son will go to court for me. And I will invest now, they'll be investing money. Now,
I mean, this is so frustrating. Well, Airtel assured us that they're working on it, have been doing so for the past 1 week, 10 days. I don't know that I got very much out of that.
I didn't hear anything.
Yeah.
The sense I made of it was talking about the dilatory nature of adjudication, from the High Court to the Court of Appeal and to the Supreme Court.
Matters have been adjourned till Thursday, but that has fallen into a holiday. So maybe, I don't know, it remains to be seen what will happen, but one can say that maybe the very next day might possibly be the day that these matters will now be, the matters before the court, that is to whether he will indeed grant in the first instance the injunction sought.
There's a new development anyway.
What?
Governor Ikpeazu has filed a full and substantive appeal. Before now,
Has he just done that, or that was done?
as at yesterday, before the close of business yesterday.
Which is different from that which was said to have been appealed and shown to
Yes,
the other party?
what you file first a notice of appeal.
Okay.
As we speak, before the close of business yesterday, or day before
A
yesterday,
full-blown appeal has now
full-blown
been filed.
appeal has now been filed.
Okay.
With 50 grounds of appeal.
Okay, so the
So
notice...
that has changed
for
the character of the case.
For us laymen, the notice means that just hear ye this.
No.
I am going to appeal.
No, that's not what it says.
Okay.
Usually, they are practical things that lawyers do. When a court delivers a judgment, sometimes because of the nature of the matter,
Yes.
and because the other side, the adversary, may wish to exploit the fluidity of the situation
Absolutely.
and cause mischief. Whether you had the court right or not, just listen. Immediately you formulate your notice of appeal and file it before you get the
Record.
judgment
The
and
full
record.
judgment.
Yes. To be able to pinpoint grounds of appeal and all that. What is done?
So it's a default mode thing.
Exactly.
It's like default mode.
Which the law creates.
Which,
Appeal.
exactly. Which is
Even
also,
before hearing the
which is
reading
also
the
going
full
to be
judgment.
the situation once a court decides that I gave this judgment. You are now asking me to stay. I've looked at your grounds of appeal. I'm not going to stay. The moment he says I'm not going to stay, your people are already in the Court of Appeal
Filing.
to file a similar application for stay of execution. so that that window
Will be closed.
will be closed. Otherwise, a lot can happen. So they know how to do it. But that's why I'm saying
we know how to do it.
lawyers all know how to
and
do
that's
this.
why I'm saying that.
We know how to do it.
My friend may argue from a position of an insider, somebody who is. But that's why I'm saying, look, you may be under pressure. The Abia State High Court route ought not to have been taken if things were okay. And that's why I said,
Things were not.
and my learned friend said, yes, you have to panic. Because the airwaves
Said there was
were
plenty of-
saturated
yes.
with the announcement that, oh, you know, somebody's going to be sworn in and all that kind of thing.
If you were governor in that situation, what would you do?
In
You-
fact,
you- you would drink champagne?
I will stick by the
I
rule of
remember.
law.
What's the rule?
GT?
Going
I
to
will
the
GT.
court, going to the
GT.
Abia State High Court is the rule of law.
I will
GT.
stick to the federal.
GT, I
You
remember,
will
I
step
remember
back.
reading. I remember reading that Chief Awomola, you know, for Ikweazu.
Yes.
He actually was complaining that they were seeking, the other party was seeking to alter what you lawyers call the res.
Absolutely.
Of the matter.
Yes,
Absolutely.
That's the argument that lawyers who are working on this.
The
matter
rest
say.
was under serious threat.
The rest was the governorship.
Was
But
under
you know,
threat.
let me just say this so that we put things in proper perspective. Now, ordinarily, when you have a three-step or three-layer judicial system, and the court of first instance has just decided the matter, and from all historical standpoint and all that we know, given the stakes, certainly was going to be an appeal. So you will imagine that, until this issue is exhausted throughout the entire gamut of the judiciary, we aren't going to have a complete resolution. However, the law does not say that if somebody against whom a judgment had been rendered does not appeal, that matter cannot be resolved at the level of the High Court. As a matter of fact, the Electoral Act provides that if within 21 days of being declared a governor, there is no appeal against, there is no petition against it and all that. No, if there is a petition that is decided
Yes.
against you,
Yes.
the sitting governor, and within 21 days, you do not appeal that, of course you have to vacate
Absolutely.
the office. You know, so
Okay.
the matter can indeed be resolved
Okay,
in a
it's
tribunal
possible.
of first instance.
Again,
or
it's
a court
possible.
of
But
first
as you
instance
said,
and all that.
lawyers on both sides know all of these windows, and the ones
We
that
know,
are
we
the
know.
ones that are seeking to widen the opening of the windows are doing so. The
That's
ones that
what
are
they are-
seeking
that-
to slap
that's
it
what they
shut.
are doing. So
Yes,
because-
That's exactly what
Marvelous.
you would do
Thank you
if
for
you
holding
were
on,
a
Marvelous.
counsel in the matter.
Let's see
You
if
would do the same
Airtel
thing.
will let you say something. Go ahead. This thing is getting. Anyhow, please just bear with us. The telephone is a very important part of this particular program because our panel extends to the home.
Absolutely.
And we get questions and we get contributions. But this thing is
Mr.
going
Presenter, let me make this point.
to. My name is Yori. Yori.
Mr. Yori, okay. Let me make this point. That order of the Abia State High Court is the only reason why Dr. Okezi Ikpeazu remains governor of Abia State today. In law, there's a doctrine called standing by. In law, you are expected to be proactive, to defend what is yours.
And if need be, thwart
No,
any
no, no.
judgment
No.
contrary to your
You are-
position.
You should take proactive measures, which was exactly what the governor did. If he hadn't,
by any means necessary.
going to court is not an unlawful means, for goodness sake. He went to court. He didn't carry a gun. He didn't go to the airport to wait for Mr. Oga. He simply went to court.
It was in court.
He went to
The
court.
judgment was rendered
But you see,
against him.
That's what I'm saying. No,
the
no, no, no.
governor
Not to
was
have
already in court
replicated
now.
that.
When you
Like,
say he went to
listen,
court.
court.
listen.
He went. This is
Listen,
the point. Thank you,
the
Mr. Oguye.
issue
He went to a different court, and that is
absolutely.
what you lawyers have
The
said
issues
is
are
something of
the
an
issues-
abuse of the process.
No. There's no abuse. You only talk about abuse where there are similarity in issues. The issues before the High Court of Abia State was completely different. Swearing in of anybody was never part of the judgment of Justice Abang.
Okay.
That
Okay.
takes the Chief Judge of Abia State was not a party before Justice Abang,
And
but was a party before the High Court of Abia State. That takes it.
Because she was crucial.
Very crucial.
She was crucial.
The
because-
Constitution requires her to administer the oath.
Under Section 287, is he an authority?
Who?
Section 287 that says that the judgment of the High Court or the Court of Appeal and the Supreme Court is binding on all authorities and persons. Is
You see,
the Chief Judge of Abia State an authority for the purpose of enforcing that judgment?
the issue is this.
And so she
There
would
is-
also be bound.
There was a court order served on the chief judge. Every court order is valid until set aside on appeal.
No matter how contradictory.
Yes, whether you agree with the order or not.
You see, this is the problem.
Yes.
This is the problem when you learned people are enjoying yourselves because this is normal
The-
fare.
the
This is
order of
this is what you guys go and study.
The order of the High Court of Abia State
a lot of us are seeing that
is
this
as
matter.
valid as the judgment of Justice Abang. These are two courts set up by the Constitution.
Even though they're working against each other.
It doesn't matter. The order made by the High Court of Abia State is valid until set aside.
But when you say it doesn't matter,
it
this
matters.
is it,
It
especially for the
matters.
quote unquote unlearned
It
people of
matters.
society, you
know,
then look at
the
look.
judiciary will be made a laughing stock.
This
No.
this is one of the
It matters.
issues.
The issues,
You know-
if the issue before the High Court of Abia State was the same thing
Okay, I
as
understand.
the one
that would be
decided,
abuse.
it will be abuse. There's no abuse here.
It was the same thing.
It was not.
You know,
Okay,
lawyers
so I
can
understand
juggle.
you.
That's why I said that.
we can't
Lawyers
spend too much time on it.
Lawyers can juggle names
Yes.
of parties.
Juggling is
You
part
can-
of procedure. If you make a mistake, if you make a mistake,
I rest my case.
you're
I'm
in-
not
you're in-
arguing.
there's a difference between TVC as a television station as an entity. There's a difference between TVC and the owners of TVC. If you get
In
an
law.
order in law,
In law,
if you get an order,
TVC is a legal person.
absolutely. If you get an order against TVC, that order does not extend to the owners of TVC, except the order says so.
So relate that example to the point. To
Now,
the point here.
it is related because the issues, I'm talking about issues now. The Chief Judge of Abia State was not a party before Justice Abang.
Okay,
Not a party at all.
Okay, fine. We've got to go. But I think the one that we don't need to argue about, even though the arguments are very, very enlightening, is that Justice Okon Abang is now going to rule or pronounce on the application before him to vacate his own order.
Yes.
I don't think so. There's a full appeal has been entered. A full appeal has
And the
been
effect
entered.
of that would be,
The
very,
effect-
very briefly.
Yes, the
would
effect of that would be-
Does it obliterate the need for Justice Abang?
Justice Abang can no longer rule on this matter.
Is that factual? I'm just checking.
I don't know
The,
what
the appeal has been entered.
No, I don't know what my learned friend means by the appeal being entered. Under the law, an appeal is deemed entered when the record of appeal, that means the entire record
Has been transmitted.
has been transmitted
That has been done.
to the Court of Appeal and entered there.
That has been
So
done.
once that is done, then that means the lower court can no longer deal with the matter.
Absolutely.
Okay.
But you know, we are dealing with a very fluid matter now.
Okay.
An
Maybe
application has
just
been
15
argued.
seconds.
An application has been argued. The court is to deliver the ruling on the application.
Sorry, there was no argument. The application has not been argued.
Well, I'm
It
not
has
a-
not been argued.
Thank you very
I
much.
can confirm that that
because
application
you're part
was,
of the team, right?
I am not a part of the team, but I know.
But he's very, very close to
Yeah,
the legal team.
Absolutely.
And so you are saying you know
the
their every
application
move.
for stay has not been argued. The records of proceedings, every
In fact,
record has been
and
entered.
Just to say that Mr. Memanka, you know, he came to us when we wanted to get the SAN on the case. This is Ananaba, SAN, Dr. Ananaba. He had said that, look, I'm too far away, but someone who is just about as knowledgeable on all aspects of the case as I am will be coming.
Even if it's not too far away, I won't expect him to come.
Absolutely. He
And be discussing
could,
the
he
matter.
couldn't have come. He is a counsel
Because
in the matter.
of the ethics of the profession.
Exactly.
Absolutely.
Okay, so I want to thank you both, gentlemen. It's been very, very enlightening. We're still trying to ponder it. Those of us that are lay say, okay, so where does all of this lead us? Because you have courts contradicting each other, and they say it is proper, it is allowed, so far as it is done within the process and the procedures. It is allowed.
From their own perspective.
From But thank you very much, Mr. Ogunye. GT Ogunye, lawyer, public affairs analyst, and thank you very much, Leonard Onyebuchi Ememanka, lawyer and public affairs analyst. Thank you both, gentlemen, for coming on the program. I'll be back tomorrow, God willing, with a fresh edition of the program. I'm Yori Folani. Bye-bye for now.